On this episode of Charged and Disbarred.
If you were a criminal in Australia, you'd want Andrew Fraser as your lawyer. He represented the most notorious of the notorious. Pretty soon things were out, and it was all due to a $1,000 a day cocaine habit.
He found out that the person's signature that he witnessed had been murdered. You cannot witness a document if the person is not there. How could he continue to practice after 33 years, 17 formal complaints?
Judges and attorneys are like kings and knights in their own realm. It is unthinkable that in a moment of madness it can all be thrown away. Charged and Disbarred explores the true life stories of attorneys who have fallen from grace. Hear firsthand accounts from the victims, detectives, and prosecutors who brought these disgraced attorneys to justice. This is Charged and Disbarred. Melbourne, Australia. The country's second largest city is located on the southern coast in the state of Victoria. Home to over 4 million people, Melbourne is considered the nation's cultural capital. It's a bustling international center for finance, commerce, arts, education, and entertainment. The mild climate makes it one of the most livable cities in the world. Located on the natural bay of Port Phillip with scenic coastal beaches and snow-capped mountains just hours apart, Melbourne is the perfect setting for a world-class city. But like any major metropolitan area, Melbourne has a shadow side, places where criminality corrupts the fabric of society, and those who work against that corruption sometimes can't help but be touched by it.
If you were a criminal in Australia in the 1980s or 1990s, you'd want Andrew Fraser as your lawyer. Andrew Fraser was the F. Lee Bailey of Australia. He represented the most notorious of the notorious. He represented cop killers. He represented mobsters. He represented footballers. He represented celebrities. He represented gun runners. He represented anyone who was anybody in any matter relating to criminal law. And he was one of the finest criminal lawyers in Australian history.
Andrew Fraser's success as a trial attorney, or barrister as they're called in Australia's legal system, brought him wealth, respect, privilege, and celebrity. How then did this brilliant family man with a gift for the law and a flair for showmanship end up here? Maximum security in the Fulham Correctional Center. Incarcerated for 5 long years, side by side with serial killers and child molesters. What caused Andrew Fraser to trade his bar association number for an inmate number and to share the same fate as criminals so despised that Fraser would likely never have considered representing them? Andrew Roderick Fraser was raised comfortably in Camberwell, an affluent neighborhood in the city of Bundara, where hilly streets are lined with Edwardian and Victorian homes. Though his father's alcoholism cast a shadow on Fraser's childhood, his mother and grandfather encouraged and inspired him. He excelled in athletics but lagged in academics. His mother spurred him to complete high school, and he went on to study at the prestigious Wesley College as his father had before him. There he discovered law, and his legal career path came into focus. He would follow proudly in the footsteps of the grandfather he so admired. He married his fiancée Diana and became a father to a son and a daughter. His passion for the law and the same competitive personality that made him a strong athlete served him well. Fraser found success and enjoyed a growing reputation in the field of criminal law. His better-known clients included Perth business magnate and art collector Alan Bond, disgraced rugby footballer Jimmy Krakauer, and multiple Australian organized crime bosses, including Dennis, Mr. Death Allen, and Louis Moran. Fraser also represented 4 men accused of brutally murdering Victoria police officers in a high-profile case. Fraser's defense of these notorious killers did not win him any friends in the law enforcement community. Still, he was at the top of his profession. Andrew Fraser's transition from revered barrister to convicted criminal is a case study in hubris. In recent years, Fraser has admitted that he was fascinated by the seedy, alternate reality of Melbourne's criminal underworld. It was exciting and markedly different from his own sheltered upbringing. At first, Frazier's interest in criminals and criminal enterprise may have made Frazier better at his job, but at some point, Frazier made a grave mistake. He began to socialize with his clients.
The problem that happened with Andrew hanging out with so many drug dealers and criminals was that Andrew Frazier himself became addicted to cocaine.
With expensive cars, a $2 million waterside mansion in a Tony neighborhood, and a house in the mountains for family ski trips, Frazier's increasingly affluent lifestyle now matched that of some of his most notorious clients. And what began as recreational drug use grew to be a serious problem for him.
Pretty soon things unraveled for Frazier, and it was all due to $1,000 a day cocaine habit.
Frazier represented major drug dealers, and now this duty-sworn officer of the court had become a client to the very criminals he was trying to keep out of jail.
Cocaine was interfering with his ability to practice law. People that he knew or worked up against or saw him saw a different man, a changed man, someone who wasn't the sharp, bright, cross-examining, fierce criminal defense lawyer. They found him disheveled. They found him disorganized. He wasn't making a lot of sense.
A colleague and friend hailed him one day from across the street and invited Frazier to coffee. But Frazier waved him off and called out loudly that he was going to get a big bag of white stuff. To make the incident more bizarre, Frazier's total absence of discretion occurred in a place where lawyers, judges, and police tended to congregate. At least one long-standing friend began to wonder if Frazier was actually trying to get caught. But perhaps the simpler explanation for Frazier's brazen behavior lies in the tendency of cocaine to make the user feel invincible, inexhaustible, bulletproof. For a trial attorney who faces high-pressure situations on a daily basis, the allure of cocaine proved irresistible to Frazier. It became part of his lifestyle, as his connection to reality gave way to delusional thinking and poor judgment that would speed his downfall. In the grips of addiction, those around Frazier could only hope he might find a way to halt the downward spiral and redeem his career, his reputation, and heal the damage to his family.
His usage of drugs was becoming widely known.
Frazier later claimed that at about this time he had discovered a scheme within the Victoria Police Department where drug squad detectives were pocketing ill-gotten profits from a methamphetamine drug sting operation. Frazier claims that his threat to report police wrongdoing is what caused him to be targeted by the Victoria Police.
And around this time, the police were already noticing and had heard that Frazier may have been involved in more than just recreational use of drugs. But they were tipped off that he was getting involved in potentially smuggling drugs.
Police went to the Victoria Supreme Court and obtained warrants to plant listening devices in his office, home, and car for what became known as Operation Regent. The bugs gave the police the evidence they needed to make multiple arrests. The secret recordings revealed the shocking extent of Frazier's own drug problem, but they also proved the lawyer had become an accomplice in his former client's drug trafficking activity. The lawyer had conspired with his own drug supplier, Warner Paul Roberts, to import 5.5 kilos of cocaine from the West African Republic of Benin. The drugs were to be concealed in bolts of wool and smuggled into Australia by an unwitting female accomplice. If caught, the woman was set up to take the fall for the whole scheme. Police arrested Frazier on September 13, 1999. Charges included conspiracy to import cocaine, possession of ecstasy, and drug trafficking. Frazier now found himself in an ironic twist of fate, in need of an excellent criminal defense attorney.
In 2001, Andrew decided to plead guilty to the importation charge. Now, Andrew expected at this point that he was going to get a pretty light sentence. In fact, he believed that he was not going to get a jail sentence at all because he had no criminal history. He was obviously a drug addict, and that was what contributed to his downfall, and that it was very unlikely that he would reoffend again.
By then, however, Frazier had long ago squandered all the goodwill he had accumulated during his career. Now the police saw a man who not only defended but associated with criminals. His former colleagues saw a man whose outrageous conduct had given them all a black eye. Frazier's hope for mercy was a lingering delusion. In court, the Honorable Judge Leo Hart threw the book at Andrew Frazier.
He was sentenced to 7 years of prison with a minimum of 5 years of prison time, having to do 5 years. And on top of that, he was required to do his prison time in a maximum security prison. So that was a significantly longer, much harsher sentence than Andrew ever anticipated.
The judge explained his reasoning behind the harsh sentence. You had bound yourself by oath to uphold the law and to conduct yourself honestly. To behave in the illegal, dishonorable, and disgraceful way that you did involves a degree of public scandal, which reflects on the profession as a whole. On your own admission, you have been breaking the law with increasing frequency by possessing and using cocaine. A legal practitioner must not succumb to such temptations.
The reason why Andrew received such a harsh penalty was because the violation occurred during the process of his engaging as a lawyer.
The once revered Australian barrister sent to prison, held in so-called protection among prisoners deemed to be prone to violence due to the nature of their crimes. His peers were now criminals hated even by other criminals. By his own account, he became depressed and spent most of his time reading. Few rise to such lofty heights as Frazier did in his career, and very few sink to such lows. Was it possible that Frazier might find redemption in this, the unlikeliest of places?
Andrew's incarceration in a maximum security prison led to a very unexpected outcome. One of Andrew's cellmates was a serial killer by the name of Peter Dupas. Peter had been convicted of multiple murders, but he was a suspect in a particular murder, but the police never had enough evidence to pin that murder on him.
Dupas grew to trust the former attorney and perhaps hoped to obtain some free, high-quality legal advice, but Dupas overplayed his hand. He recounted his past crimes to Frazier and in the process revealed that he in fact had killed Mercina Halvagas. The young woman had been tending her grandmother's grave in Faulkner Cemetery in 1997 when Dupas stabbed her to death. Dupas even pantomimed his crime for Frazier in their shared cell and provided key details of the crime that only the killer could have known.
Andrew became the link in the chain. The admissions that his cellmate made to him became key evidence, which Andrew turned over to the authorities. He actually did the right thing. Based upon Andrew's testimony, in fact, the police were able to bring murder charges against the cellmate and were able to successfully prosecute him, convict him for the murder of the young woman, the crime that had gone unsolved.
Frazier's redemption reduced his sentence by 2 months and earned him a transfer to a less restrictive prison. He also qualified to receive 1/3 share of the $1 million reward that had been posted for information leading to the conviction of Halvagas' murderer. Frazier was released from prison in the dark of night, as other inmates at the facility learned that he had testified against his cellmate Dupas.
Andrew was disbarred as a result of his criminal conviction. He's not been able to practice law since then.
Frazier's wife divorced him while he was in prison. According to Frazier, he kicked his $1,000 a day cocaine habit before being incarcerated, and he regrets the turn his life took. He lives a quiet life in the bush with his partner, an artist he met on a blind date, and spends his time with his children who are now grown. As for his new occupation, Frazier is a published author.
He wrote several books, and one of which has become a television series in Australia that was about his life and times.
According to McCabe, Andrew Frazier's great fall from high, where he was at the pinnacle of an elite segment of the legal profession, is not entirely surprising.
In my experience representing attorneys, it's not that often that the attorneys themselves become criminals, but a significant factor in many disciplinary cases is substance abuse, alcoholism and substance abuse, cocaine abuse, crystal meth. It's these attorneys who end up dropping client matters, who end up neglecting client cases. Occasionally, their need for money to fuel their drug habits will lead them to things like stealing from their clients, violating trust funds. So there is definitely a connection between addiction and unethical conduct. A very high percentage of lawyers suffer from addiction, and it's not a surprise that many clients come before the bar. One of the root causes of their malfeasance is an underlying addiction.
Still to come on Charged and Disbarred.
Later on, we found out that the person's signature that he witnessed had been murdered. You cannot witness a document if the person is not there. How could he continue to practice after 33 years, 17 formal complaints?
This is Charged and Disbarred. Isaac Alexander Brott was admitted to the bar in Victoria, Australia in 1976. For most of his career, he practiced law at Brott & Company from the second floor of a charming Victorian building he owned at 495 Little Bourke Street in Melbourne, just around the corner from the Supreme Court of Victoria. He advertised his services as an immigration lawyer and practitioner of family law. The ensuing decades of mistakes, malfeasance, and misconduct on the part of Mr. Brott have been detailed by academics as a case study in history of legal disciplinary action. How could a lawyer who flagrantly circumvented the law and rules of conduct have remained in practice for over a quarter of a century? Trouble with Brott's conduct first came to the attention of the bar in 1985.
So 9 years into his career, Mr. Brott gets his first criminal charges for forgery and uttering. Uttering is where he used the false paperwork.
These early complaints should have put Brott on notice that he needed to bring his practice into compliance with the standards of the profession. Instead, Brott's habits and practice took a turn for the worse.
He was asked to witness a guarantor's signature. That guarantor wasn't in the office. Clearly unethical behaviour. You cannot witness a document if the person is not there before you to sign it. The interesting part is that later on we found out that the person's signature that he witnessed had been murdered.
This misdeed might have gone unnoticed had the guarantor not been the victim of a violent crime and attracted the scrutiny of police.
Mr. Brott knowingly witnessed a signature of somebody that wasn't in the room with him.
Brott was convicted for his complicity in a proven case of forgery, a crime that should have had serious repercussions for the continuation of his legal career, but that didn't happen.
So he appealed to the highest court, which is the High Court of Australia. That appeal took 5 years before a judgment was delivered. So in that 5-year period, Mr. Brott was permitted to continue to practice. I think Mr. Brott was permitted to continue to practice because the regulatory regime that we had was not strong enough. It wasn't protecting consumers of legal services as it should have been. I dare say today could be a different story. Although he had all of these complaints made against him, he continued to get clients. It didn't seem to impinge upon his reputation. For me, being a lawyer, reputation means everything.
Many of the reports of impropriety from clients, judges, and other legal practitioners were dealt with behind closed doors rather than in public proceedings, according to our legal expert, Marlene Ebinger. The extent of these complaints would not be compiled before one central regulatory body until 2008. Until then, evidence of Brott's myriad troubles were scattered throughout the system, and the number and variety of his transgressions only continued to grow.
Mr. Brott was involved in family law proceedings. He acted for a wife. He went to court and spoke up against his own client in an effort to secure his legal fees. He was concerned that the wife, when she got a settlement, that she would not pay him. That's giving evidence against your own client. We have rules that guide us as lawyers. We have things called legal professional privilege that we can't talk against our own client. Mr. Brott had given some evidence at a royal commission, and the evidence was questioned by the Supreme Court and by the public prosecutor, and they deemed it to be that he was in contempt. Not long after that, there was yet another disciplinary proceeding against Mr. Brott, this time because he didn't cooperate with the then legal regulatory body, the Law Institute of Victoria. He was receiving a number of these complaints, but he was not cooperating with the regulatory body. That's another cause for disciplinary action. Mr. Brott also had the habit of overcharging his clients. He acted for one personal injury client. She received a claim, a compensation claim of $25,000. He rendered his bill of fees for $23,000. That meant the client who would have suffered injuries to be able to receive that payout was only going to receive $2,000.
Those fees were later adjusted in favor of the client, but Brott frequently found himself defending cost irregularities. New rules were established in 1989 to ensure that lawyers in Victoria would receive continuing education. Brott flaunted these rules, but the reprimands and complaints had little or no effect on Brott's career.
There are rules about charging and how we charge. In fact, since that time, the rules on lawyers have become much stricter. We now must provide cost agreements and disclosure statements clearly stating what we're going to charge a client for the work that we do for them. Mr. Brott's checkered career continued.
Brott committed another offense that would cause problems for him years later. From 2001 to 2003, Brott became associated with Xavier David Holden, who had been convicted of drug trafficking in 1998. Holden operated UCI Consulting from the third floor of Brott's building at 435 Little Bourke Street. Renting office space to a convicted felon was unseemly, but not inappropriate in of itself. However, it was later revealed that Holden had extensive access to Brott's legal offices on the second floor. Brott admitted in proceedings at the Victorian Civil and Administrative Tribunal that he even helped Holden pose as a lawyer. He gave Holden or allowed him to use business cards and letterhead that suggested Holden, a convicted criminal, was actually a lawyer. Holden improperly collected money from Victoria Legal Aid under the pretense of being a legitimate legal practitioner. Brott signed letters prepared by Holden, and he passed correspondence through the law firm to Holden. He even paid counsel fees out of Brott's legal trust account. Yet it'll be years before this activity became a problem for Brott. Over the years, Isaac Brott was also plagued by personal tragedy and financial problems.
In 1990, Mr. Brott was mugged, robbed, and stabbed 19 times. I can't find any evidence that that's got anything to do with his practice. It might just have been his misfortune at the time.
A decade later, in 2000, his daughter was diagnosed with a brain tumor and underwent a year of chemotherapy and radiotherapy. Brott would claim in proceedings before the Victorian Civil and Administrative Tribunal that these incidents should be mitigating circumstances in his conduct. The tribunal was not persuaded by the argument in light of the severity and extent of his many transgressions, but it's possible that other authority figures behind closed doors might have been more sympathetic to similar pleas for mercy. There were no public proceedings against Brott between 1990 and 2003. That doesn't mean he wasn't causing problems for courts and clients during that time.
What intrigued me so much about this case is that how could he continue to practice over a span of 33 years after he'd had so many complaints made about him?
Eventually, Brott's extensive misconduct caught up with him. The egregious charges that had helped a convicted felon pose as a lawyer were found to be compelling. Brott admitted to many of the charges and was found guilty.
Up until 2003, Most of those disciplinary proceedings were held behind closed doors. Really, he didn't come to the forefront or to the attention of the public until 2003.
His past malfeasance would continue to be uncovered for the next several years, but he still continued to practice law. Brott still managed to keep a low profile with the public despite his many problems until 2005, when he made a dramatic announcement to the press regarding the high-profile death of QC Peter Reyes. The revered lawyer had been found dead in a hotel room in the company of prostitutes and with cocaine and heroin in his bloodstream. Brott announced that he had filed a complaint with the bar about Hayes' drug use years earlier. He had apparently learned of Hayes' drug problems from one of his clients. Brott went so far as to say that action by the Victoria Bar to investigate his report of drug use and a reprimand to Hayes might have saved the barrister's life. But the bar at the time of the complaint had told Brott that his charge lacked evidence. Hayes had actually represented Brott 3 years earlier in one of Brott's many charges before the court. Momentary fame would not forestall the excruciatingly slow wheels of justice that were gradually being brought to bear against this Melbourne barrister.
Finally, in 2008, the regulatory body said enough is enough, and he was barred from holding a practicing certificate until 2014.
Unbelievably, Brott was still not actually disbarred. His practicing certificate was canceled, and he was told he could not reapply for a certificate until 2014. But that changed in 2011.
In 2011, more complaints come out about Isaac Brott. This time, he'd commenced litigation on behalf of two people back in 2003 and 2004 without instructions. Related to motor vehicle accidents, he commenced proceedings without his client's knowledge.
Brott had walked into court and filed papers representing clients who had not agreed to be the party to the actions he filed. The courts found that Brott had denied his clients many rights under the law, and these actions would be the misconduct that would finally bring his career to an end.
His conduct was deemed to be professional misconduct. At that time, VCAT referred Mr. Brott finally to the Supreme Court of Victoria and asked that he be struck off the roll of legal practitioners.
Photographs or images of this attorney are no longer available to the public.
I think Mr. Brott knew what he was doing. There were many complaints made against him. There was no excuse for him to not know that his behaviour was unprofessional and unethical.
Brott had finally run out of excuses and forbearance.
After 33 years, 17 formal complaints, Isaac Brott was struck off the roll of the Supreme Court of Victoria. It means he can never practice again as a lawyer. I think in the end, Mr. Brott received just punishment for being struck off the roll. I don't want to be a lawyer associated with other lawyers who are doing the wrong thing by their clients and by the profession.